Hi, my name is Brad Boyd. I'm an attorney with the law firm of Thomsen and Nybeck, and our firm serves as legal counsel to the Minnesota Association of Realtors. Today's legal update will address an issue that continues to be in front of listing agents, buyer's agents, and banks when dealing with the sale of REO property or bank-owned property that's been foreclosed and is now owned by the bank. The question that comes up quite regularly and recurringly is, must banks who own and sell REO property follow the disclosure laws of federal law or the laws of the state of Minnesota when selling that property? And the clear and concise answer is yes. The banks must follow those laws, and any bank that owns residential property is bound by the same seller disclosure laws and other disclosure laws that are imposed upon them by Minnesota law or federal law. And whether they're an individual seller or a bank seller, there's no differentiation as to what obligations they must follow. So one of the recurring questions then is, what are the disclosure obligations that sellers and banks face? And the disclosures include, but are not limited to, first, the Minnesota Material Fact Disclosure Law. That's basically the law that says sellers of residential property must disclose any material facts that could affect the ordinary buyer's use or enjoyment of the property, or any facts they're aware of that the buyer specifically is concerned about with respect to the use of the property by that buyer. Those disclosure obligations can be found in Minnesota Statutes 513.52 to Minnesota Statute 513.60. And those obligations, again, are imposed upon any seller of residential real property, whether it's a bank or an individual owner. Now, it is important to note there that banks or individual sellers have two alternative options. One is to have an agreed waiver between the buyer and seller. So if the buyer says, I'm not interested in seeing a seller disclosure in writing, and the seller doesn't want to provide one, they can agree to waive the disclosure obligations. Most banks that are complying with the seller disclosure law tend to follow that process. If they don't want to make a disclosure to the buyer, they ask the buyer to waive the disclosure, and a written waiver is entered. The second alternative to disclosing is to have a third-party inspection provided. So what that means is the seller would hire a third-party inspector, qualified third-party inspector, the language refers to, who would then inspect the property and provide that written inspection report to the buyer. That inspection report, however, has to be contradicted by any actual knowledge that the seller has that is not consistent with what the inspection provides, or they have to supplement any missing information. So using either of those two alternatives, the seller has to, in any event, the seller has to comply with the disclosure obligations, whether they disclose or use one of those two alternatives to disclosure. That really covers the material fact disclosure from the seller side. It's also important for real estate agents and realtors who we're talking to today to recognize that there's a legal obligation under Chapter 82, which is the Minnesota licensing law, that realtors or real estate agents must disclose any material facts that affect the buyer's use or enjoyment of the property. So even if the bank waives the disclosure and the buyer waives the disclosure, or they choose the third-party inspection in lieu of the disclosure, the real estate agent is not relieved of their legal obligation to disclose. So they're parallel disclosure obligations, and whatever the bank does to waive or provide a third-party inspection does not remove the responsibility from the realtor or the real estate agent to disclose material facts they're aware of. So that covers the material fact disclosure side of the issue, but it's important to recognize that there are other disclosure obligations that a bank or any other individual seller would have to follow. One of those is the federal lead-based paint disclosure. This disclosure applies for a residential property that was built prior to the year of 1978, and that again is a federal law. It's a disclosure of any known lead-based paint hazards in the home, and that is not waivable. So that is something the bank seller or individual seller has to follow and cannot waive. Same goes with the Minnesota well disclosure law. They have to disclose, any seller has to disclose the existence of wells, status of wells on the property, and there's also a parallel disclosure obligation for septic systems. So well and septic disclosure has to be done, whether it's a bank or individual, and those are not waivable. Similarly, there's a disclosure obligation imposed by Minnesota law to disclose the production of methamphetamine that may have occurred on the property. If that applies, that has to be disclosed by a bank or an individual seller. And then there are other disclosures such as valuation exclusion if the property has been exempt from some form of taxation on the property, or if that's been deferred or there's been another valuation exclusion. And then there are also notices that have to be provided by Minnesota law dealing with both airport zoning issues as well as predatory offender notice issues. Those issues tend to be addressed in the MAR forms. They're within the purchase agreement or the seller disclosure statement. Real estate agents have to be keenly aware of the fact that if banks are using their own forms, they may not have some of these disclosures already addressed within their forms. So it is important for real estate agents to be aware of that and to make sure that's identified to the bank. There's a couple brief questions that we can answer for you, one of which is, can the disclosure obligations be waived? As was addressed briefly, the answer really is both yes and no. A seller can waive their disclosure obligations for the material fact disclosure, but a real estate agent cannot waive those disclosure obligations. A real estate agent is bound to disclose regardless of whether the buyer and seller enter a waiver. It's also important to note that although the material fact disclosure obligations can be waived, all the rest of the disclosure obligations I referenced cannot be waived. So you have to bear that in mind with bank-owned property. One of the questions that real estate agents then quite frequently ask is, how do we address this issue with a bank? As we know, many banks already are aware of the disclosure obligations imposed upon them by law, and they're following those obligations today. Certainly there are many banks that are not following the rules as well, and the listing agents who work with those properties have to be careful about how they handle it. One of the things that they can do first off is to identify to the bank that these disclosure obligations exist and suggest that the bank talk with their legal counsel as to how they're going to fulfill those obligations. Second, the real estate agent can identify what we addressed already, that the alternatives to disclosure for material fact disclosure include a third-party inspection or a waiver, so the bank can look to one of those alternative options, and the agent should remind the bank that they, the agent, will still have to disclose material facts. So for instance, if the agent walks into the property, identifies that there may have been a wet basement in the past, that information would have to be disclosed to the buyer, even if the bank does not disclose it. So at that point, the cat's out of the bag, so to speak, and it may make sense for both the bank and the agent to disclose. There is an MAR memo in the June 6th, 2009 electronic resource, the e-resource newsletter. That's available on the Minnesota Association website, mnrealtor.com. And within the two memos, we've provided, Don Smith and I from Thomsen and Nybeck have provided to the MAR a memo first dealing with the disclosure obligations, and second, addressing what banks need to be doing. And that second memo is one that real estate agents or realtors can use to provide to the bank, kind of reminding them of what their obligations are and what they should be doing. So look to those memos to the extent you're looking for help and some legal substantiation for your position when the banks are saying that they don't have a disclosure obligation. Hopefully with that brief overview, you feel well prepared to deal with banks when you're listing REO property, or the point we didn't touch upon in great detail, but buyers who are buying REO property certainly have the ability to ask for disclosures. Whether or not banks want to provide the disclosure, the buyer can certainly ask. And so with that, hopefully we've given you a good overview of what the legal obligations for banks who own REO property are as relates to seller disclosure law and other disclosures. Thank you for your time today.